Good morning or good afternoon to everyone, wherever you are located. I'd like to warmly welcome you and thank you for joining this webinar today. It's a real pleasure to see so many of you joining us and having interest in this specific case, which is the case of Majdi N. And of course, also in the work of the Syria Justice and Accountability Center. My name is Teresa Quat. I am the lead of the trial monitoring team lead, but I'm especially pleased to introduce to you my colleague Eva in more detail. Eva is a member of SJAC's trial monitoring team and based in France, and she has monitored and reported on, for example, the Dabak trial last year in Paris, has also closely followed the recent hearing on the arrest warrant against Assad, and has monitored the Majdi N case from the start to finish. And her incredible experience and expertise brings wonderful value and insights into how this trial has unfolded. She will give details on the legal specific and, of course, what it means in the broader landscape of Syria-related justice efforts. Let me briefly explain this format. I will start with a short introduction on our trial monitoring project. And the cases that we have so far monitored in brief, and then give you a bit of a context of the trial that we're discussing today. And then I will directly hand over to Eva, who will present her observations and the key takeaways from the trial. And finally, of course, a special thanks to Eva, who followed this case in great detail and with an incredible dedication, including very, very long trial sessions, often staying until 9 or 10 p.m. at night. And the work that she has been doing ensures the transparency and access to these trials for Syrian victims and families. And she's currently transcribing more than 350 pages to make them accessible to everyone in English and Arabic. With that being said, I would like to begin with the brief overview of our monitoring program and provide a little bit of context for the case that we're speaking about today. So part of SJAC's commitment to justice and accountability is the trial monitoring program that we have launched in April in 2020 with the landmark case against Anwar Raslan and Ayad Al-Kharib in Koblenz in Germany. And since then, we have systematically followed Syria-related criminal prosecutions across Europe and the United States and continue to provide independent and detailed documentation. These efforts are necessary and address a persistent gap in official court transcripts and translations, which is a significant limit to the access for Syrian victims' families and, of course, the broader civil society interested in these cases. Since 2020, we have monitored several proceedings against former Syrian government officials and affiliates, but also members of ISIS and other armed groups. For instance, we followed the 3.5-year-long trial of Ala M, a Syrian doctor who was sentenced to life imprisonment just recently in June in Frankfurt in Germany. The already mentioned in absentia trial in France, in Paris, and also the trial of a former NDF member, Ahmad H., who was sentenced to 10 years for war crimes and crimes against humanity in Hamburg, Germany. In addition, our team has monitored several cases involving foreign fighters and ISIS affiliates in Germany, the Netherlands, and also the US, such as the well-known ISIS Beetle case that was heard in Virginia. We have also monitored and published widely on the Hasna A trial, which took place in The Hague in the Netherlands, concerning the genocide case, the genocide charges against the Yazidi community, and she was also convicted. And currently, we are monitoring a trial also for genocide charges in Munich in Germany. Our monitors compile trial reports, draft thematic analyses, and also create additional resources that are available in English and Arabic. And they are aimed at building a public record, as well as improving transparency and access to justice mechanisms. Today's case focuses on the first Syria-related trial in France based on genuine universal jurisdiction. Eva will go into detail on the legal aspects of that. The case against Majdi N, also known as Islam Alouche, who's the former spokesman of the armed group Jaish al-Islam, was heard before the Assise Court in Paris from April 29 to May 28, 2025. And the accused was charged with complicity in war crimes, of forcibly recruiting minors, and the participation in a group formed with intent to commit war crimes. These crimes were committed in Syria and Turkey between 2013 and 2018. The court sentenced him to 10 years imprisonment, but the verdict is under appeal, so it is not final yet. The trial spanned over 18 trial days, involved Syrian and French civil parties, and was supported by court-provided French-Arabic interpretation. Eva monitored all phases of these proceedings, including the questioning of the accused, testimony by expert and Syrian witnesses, and of course the closing argument, which we will hear in a second. Following this trial, Eva is preparing thematically organized and accessible reports on the trial that will be available on our website, as mentioned in Arabic and in English. And these materials are designed to provide clarity and context across the proceedings, make them more understandable and accessible for international audience, but specifically also for, of course, Syrian interested and families of the victims. I would also like to encourage you to sign up for our newsletter, where we will regularly inform everyone when new reports are being published. And with that context in mind, I'm pleased to hand over to Eva, who will guide us through the details of this trial, the legal arguments presented, and give us some key insights from the courtroom. Thank you.
Many thanks, Teresa. And again, good evening or good morning, everybody. Marhaba jamian. Thank you, Teresa, for this great introduction into our trial monitoring work and the present case as well. Before getting into details on our topic, maybe a few words to give you some context about where I'm talking from. I'm Eva Lajarige, and I worked at various positions at the French Ministry of Justice before joining SJAC. I started with preventing violent extremism among young offenders, and that was an experience that made me aware of the importance of choosing fair means, I would say, to pursue legitimate goals, such as, in our case, fighting the Syrian regime. I then shifted to international cooperation in judicial matters and investigation, with a particular focus on Arab countries. And that brought me to work both in French courts on international criminal cooperation and in another context on analysis of evidence related to crimes committed in Syria. For several years now, I closely followed developments in France regarding prosecution of crimes committed in Syria, and eventually joined SJAC as a trial monitor and attended the trial of Majdi N. Michael, if you could move forward with the slides, please. As Teresa said, the trial spanned over 18 trial days, and today I'm going to give you an insight not only on the trial, but also on the background of the case, because the investigation lasted for 5 years. Majdi N being arrested in January 2020. And then I will move to the trial and into the main aspects of the debate of the evidence that were presented in court, and of course, the verdict. I hope that way I will not be longer than 30 minutes to leave for everyone opportunities to ask questions. Just a quick reminders, you can write your questions in the chat, both in English and in Arabic. We'll have someone translating them. Great. first of all, some words about the personality and life of Majdi N. He was born in 1988 and was the fifth of six siblings. What was remarkable in court is that his family background was presented as rather positive, with both parents working on activities related to the middle class. And her mother studied at a time where Majdi Nema said it was quite unusual for Syrian women. His brothers and sister were well integrated as well, being all doctors or engineers or teachers. Himself, he studied geology in 2006 and then switched to medicine, but he was arrested under the Assad regime in 2009 and then detained first for a short period of time in branch 227 and then for 45 days in the branch Palestine. That is where he spent like all that period with Zahran Aloush, and they got right away very close to each other. Zahran Aloush being the one who will then become leader of Jaish al-Islam. Quite remarkable also was that his brother was detained under the Assad regime for 5 years and spent most of his detention in Sednaya. After he was released in 2009 again, he could not go back to university, so he had to join the military and did his military service, but not in any unit, as the presiding judge pointed out, because he served in a unit that was responsible for repairing and maintenance of all communication equipment. Then in 2012, he defected with 8 other soldiers and rapidly joined the opposition armed group, Liwa al-Islam, which then became Jaish al-Islam, and he settled in Eastern Ghouta. That's when he adopted the name of Islam Aloush, and Zahran Aloush soon requested him to become the spokesperson of the group. He then left Syria at a date that was debated in court, because himself said that he left on May 28, 2013. He left Eastern Ghouta at that date and never came back. And of course, the prosecution and also the civil parties brought evidence that he might have come back to this region after that date. But anyway, he was in Turkey between 2015 and 2019, where he studied political sciences. And noteworthy is that his 2 first years in university there were financed by Jaish al-Islam. Another important step in his life was that he left the group, he said in May or June 2016, but then more officially in 2017. And after that, while still in Turkey, he was granted a scholarship in an EU exchange program called Erasmus, and that's how he arrived in France in November 2019. Now, before he arrived in France, the SCM, the Syrian Center for Media and Freedom of Expression, led by Mazen Darwish, already filed a complaint against Jaish al-Islam as a whole. And when they were notified about his arrival in France, an additional note was added to the complaint, and the French police opened an investigation in January 2020. A few words about his arrest. It is remarkable that he was not arrested by any police service in France, but by the elite unit of the National Military Police, which is called the GIGN. And the GIGN is deployed for very serious cases, basically. So that was a contrast with the fact that he was carrying no weapons, and that the investigator afterwards could find no evidence of violent purposes that he had, or maybe the idea that he was plotting an attack on the French soil. That was not the case. But still, the GIGN was asked to arrest him. The presiding judge described this arrest as rough. And during the debate, the picture of Face was displayed in court. This picture was taken 2 days after his arrest, and it was obvious that he had been violented because his face was bruised and swollen. And when asked about this experience, Majdi himself declared that he had difficulties to see 2 days, several days after the arrest, because his eyes were swollen, and also reported that his genital had been squashed, which is strictly forbidden under French law in a police arrest. Now the investigator of the police office, the OCLCH, which is in charge of investigating international crimes, was heard in court, and he said that an internal investigation had been launched, and that this investigation concluded to no unlawful use of force during the arrest. However, in court, both the counsels of the defense and the civil parties denounced police violence. Let's move to the key aspects of the judicial proceedings before the trial, because as I said, the investigation lasted for 5 years. First of all, the defense appealed several charges and claimed that France did not have jurisdiction to try Majdi N. Now, few explanation about the jurisdiction of French courts on crimes committed abroad by a foreign perpetrator on foreign victims. When do French courts have such jurisdiction? Well, 2 requirements are: first, that the court has to establish that the perpetrator has an habitual residence in France. And second, the charged crimes have to be criminalized not only under the French Penal Code, but also in the state where they were committed. And that's the so-called double criminality. Those questions went all the way up to the highest judicial court of France, which is the Court of Cassation. And the question was whether those requirements were met. The Court of Cassation examined the case on May 12, 2023, and concluded that those requirements were met, so they dismissed the appeal. On double criminality, maybe some explanation. They said that even though it is true that the acts must be recognized as crimes in the other country, in Syria in our case, but they don't need to have the exact same legal label. So it's enough if Syria recognizes murder, torture, etc., but it doesn't have to be mentioned as crimes against humanity in the Syrian Penal Code. That was the decision. However, after that, the investigation went on, but the Court of Appeal and also the investigative judge concluded that some charges that were brought at the beginning against Majdi N should be dismissed. So you can see it on the slide. The most important one, I would say, was complicity in enforced disappearance. That was dismissed because for a person to be charged with such crime, the judge has to prove that it was an agent of the state or acting as in an official capacity. And the Court of Appeal in Paris considered that this criterion was not met in the case of Jaish al-Islam. However, they still recognized that Jaish al-Islam was responsible in the enforced disappearance of 4 famous Syrian activists. That was really at the heart of the complaint filed by the SCM in 2019. So by dismissing those charges, what the French judiciary said is that he was not accomplice of such crimes, but as you will see later, he will still be tried for some of those acts, but on another legal ground, which represented a lower level of involvement. Let's move to the parties. The parties to the case, first, the civil parties were 3 Syrian victims and 3 NGOs, the NGOs being the SCM, as I said, as well as the International Federation for Human Rights and the Human Rights League. At the beginning of the case, 5 Syrian victims had registered as civil parties, but 2 of them withdrew after some charges, and in particular, the charge of enforced disappearance was dropped. The prosecution was represented by 2 members of the Crimes Against Humanity unit of the National Anti-Terrorism Prosecutor's Office. Majdi N was represented by 2 lawyers, and the court was composed of 4 professional judges and 6 jurors. Now, what were the remaining charges after several ones were dropped? As Teresa mentioned, Majdi N was indicted for acts committed between 2013 and 2016 in Syria and Turkey, where it was based after 2015. And he was charged of complicity in recruitment of children, which constitute a war crime, and participation in a group formed with the intent to commit 6 war crimes. Here, it's important to note that under French law, the complicity is considered a more severe crime than the sole participation in a group formed to commit war crimes. So basically, it needs more evidence to prove it, and the sentence is also higher. Now, the next slide on the evidence, I will give you some details about the main documents and evidence that were presented in court, because obviously there were many. The first thing is that when Majdi N was arrested in Marseille, his apartment was seized, and the police seized his apartment was searched, and the police seized his digital devices, which were a computer, a phone, and an iPad. And the investigators retrieved a very big amount of data out of it, as you can see on the slide. Now, what were the main ones that were discussed in court? When it comes to photo and videos, we had pictures showing Majdi N as a fighter carrying weapons, obviously propaganda videos of Jaish al-Islam, also videos where we could see military parade to recruit children. The conversations would show that Majdi N was a point of contact for families of persons who were detained inside the jails of Jaish al-Islam. Those conversations also showed that he was informed about attacks committed by the group, or also giving orders in some occasions. There was a debate on conversation on Telegram because they were not accessible in the court. Can you go back to the slide before? Great. Well, so yeah, the conversation on Telegram were not retrieved early enough, so they got lost basically. And Majdi N claimed that those would have represented exculpatory evidence. Other important documents were a resume that he himself wrote, and he described his function not only as spokesperson of the group, but also as deputy head of the Office of Moral Guidance, as member of the political office, and also as a leader of training camps in northern Syria. Other important documents were programs of training camps, the question being, were those training camps targeting children or not? And another type of training programs were this time training on international humanitarian law, targeting fighters of Jaish al-Islam. And that was also an important category of documents, because on this basis, Majdi claimed that he wanted to raise awareness on those principles of international criminal law, and somehow presented himself as a reformer from the inside and as a voice in Jaish al-Islam that could avoid commission of war crimes. What testimony were available in court? More than 20 witnesses were dismissed at the beginning or during the course of the trial. I could give more detail in the Q&A about that if you want. But who were the witnesses that were heard in court then? We had 4 context witnesses. Maybe the more important ones were the former French ambassador in Syria, who contributed to organizing the official visit of Bashar al-Assad to France in 2008. And the other very important witness was a French researcher who was working on Syrian armed group and met Majdi in Turkey several times. And he was the one who then welcomed him to France. So the court had many questions for him, and he was heard about 6 hours. 3 investigators of the LCLCH were heard, as well as 3 experts on Majdi's personality and background. We had 4 civil parties. The 3 Syrian were victims of Jaish al-Islam, and also Mazen Darwish as representative of the SCM. 8 witnesses, or 8 Syrian individuals, I would say, made a direct statement in the court, but only 5 of them were considered formal witnesses, meaning that their statement could be used as evidence. The other 3 were only there for informative purposes. The court also based its verdict on 14 testimonies that were indirect. They were either read aloud in court, or videos of the testimony were displayed, or only the content of them were mentioned. Regarding evidence, it's important also to stress that the SCM provided a big amount of documents within the complaint that they filed in 2019. In this complaint, and then also through research of the prosecution, all that brought additional open source documents and evidence, as well as international reports related to the case. I can mention videos of executions of leaders of other factions, for instance, or ISIS members, videos on operation of Jaish al-Islam, videos in training camps, an organizational chart of Jaish al-Islam where Majdi was mentioned, as well as tweets published by the group on social media. Regarding international reports, we had reports of the International Commission on Syria and the IIIM, but also of the Violation Documentation Center of the SCM. And an important one was a report on children recruitment in Syria that stated that 103 children were inside the ranks of Jaish al-Islam. Let's move to the debates. The trial started with the defense challenging the court's jurisdiction on several grounds. the most important one being that the context in Syria had changed and that Syria was now able to judge Majdi by itself, stressing also that the judiciary was independent. They use the arrest of Jaish al-Islam's new leader, al-Buwaidani, in the Arab Emirates, United Arab Emirates, to justify the fact that Syria could also somehow prosecute affiliates of opposition groups. I can also go into details on the arguments of the defense to challenge the court's jurisdiction later. So when it comes to the crimes themselves, as I said, Majdi N was not indicted for having directly committed the crime, but was considered an accomplice on one charge and then to be a participant in a group that committed war crimes. So the first thing the court had to do was to prove that crimes had been committed by Jaish al-Islam. Here a few words about the main crimes at stake. First, the massacre of Adra al-Umaliyah. The Jaish al-Islam and other factions entered the city in December 2013, and they allegedly killed and kidnapped many civilians. Several statements related to this massacre, and one Syrian individual who testified in court also reported very precise information on that because they were there during the killings. The court focused also on extrajudicial killings that were allegedly committed by the group. On that point, there was a debate on the role of the judicial body that was created inside Eastern Ghouta at that time, which was called the Unified Judicial Council. And the debate was about whether this was a legitimate judicial body or not, because if it was not, then the death penalty that was issued by this council could also have been considered non-judicial killings, at least. Many acts of torture and unlawful detention were mentioned, and that included children. Those acts occurred in Jaish al-Islam prisons of El Tawbeh, El Batoun, and Kahf, and several witnesses depicted those practices. Two civil parties to the case being themselves tortured in those prisons. The exhibition of civilians in cages occurred after the regime bombed Douma in October 2015, and other reaction. Jaish al-Islam allegedly placed civilian Alawite, most of them, into cages and exhibited them inside Douma, which was considered an humiliating and degrading treatment. Training of children was also, of course, at the heart of the case. One anonymous witness that could not appear in court said that he was himself recruited as a child by the group. And a civil party also mentioned propaganda posters in Douma that targeted minors. Kidnapping were also presented, mainly focusing on the 4 Syrian activists I previously mentioned. And when it came to attack of civilians, what was at stake were airstrikes committed by Jaish al-Islam on Damascus civilian neighborhoods in 2014 and 2015 that were documented by the UN. Now let's switch to the role of Majdi N in the group and the link to the crimes. So how could the court prove or deny his link with Jaish al-Islam? They mainly focused on 4 aspects of his relationship with the group and the crimes committed in the Ghouta. first of all, the question was, what was his role in Jaish al-Islam? Because it was clear he was spokesperson, and he himself argued that he was solely spokesperson and nothing else, that he had definitely no decision-making function in the group, and that he was even a reformer, as previously mentioned, when it came to training fighters on international humanitarian law. Now, the court argued that his role was not restricted to that, and that he had politics and diplomatic functions as advisor of Bahram Alouche, that he also had a role in military issues and in surveillance and intelligence. Regarding his knowledge of the crimes being committed by the group, the argument is to say that he was not aware that such crimes were committed, and if he would have been aware, then he would have left earlier. To support his argument, he said that he was not from Eastern Ghouta. So when he left in May 2013 and never came back, in his words, he had no way to know what really happened inside. And even as a spokesperson of the group in Turkey, when he was contacted by relatives of detainees or media or foreign diplomats, and he would only ask the group and had to believe what they were telling him, basically. That was his argument. But now I've mentioned a lot of witnesses who depicted scene where it was obvious that he learned about what happened there, being the extrajudicial killings, the detention, the torture, etc. As I said, at least 2 civil parties said that they saw him in detention. It was also important for him to prove that he was not in Eastern Ghouta after 2013. As I said, Jaish al-Islam mainly acted in this region. So the defense provided a timeline trying to show that after he left, he never came back. So based on testimonies, on geolocation, on meeting with ambassadors in Turkey, they tried to show that he stayed there. Or when he traveled to Syria, then remained in the north of the country. However, several counter-arguments were brought by the civil parties and the prosecution. 2 witnesses said that they left Ghouta after 2013, like in 2015, I remember. So basically meaning that it was possible to go out and come back to the Ghouta after that date. Been interviewed 3 times while he was still in the Ghouta, and those interviews were dated October and November 2013. And 4 witnesses saw him after that date until 2015 in the Ghouta. His role in training camps was also vividly debated. Nema himself, Majdi himself acknowledged that he was a supervisor of camps in northern Syria, but he denied to have ever been involved in camps in Ghouta after May 2013. However, the prosecution argued he contributed to propaganda targeting children. A civil party also saw him in a training camp, and an anonymous witness detailed his role in the organization of trainings. However, this witness could not be heard in court. And in the closing arguments of the prosecution, they had to acknowledge that they only had indirect witnesses when it came to recruitment of children. And that's why he was acquitted for several charges. Let's move to the verdict. He was acquitted for complicity in recruitment of children under 15, but convicted for complicity in conscription of children aged 15 to 18, the difference between recruitment and conscription being that recruitment is voluntary and conscription is involuntary. I can also give more details if you wish about the difference between a child under and above 15 under French law. He was acquitted for having participated in a group formed with the intent to commit the war crime of deliberate attack on civilians, but convicted for his participation in a group formed with the intent to commit the other 5 war crimes that I mentioned. I thank you for your attention. I'm available for Q&A.
Thank you so much, Eva. On point. So now we have another 15 minutes for the Q&A. Thank you so much for the presentation, for the insights and all of the details. I think you made the very complex legal process very accessible and transparent. And I would like to encourage everyone now to send their questions in the Q&A in either English or Arabic, as Eva also mentioned. And if you would like to pose your question speaking, then please let our technical assistant know so we could give you the right to speak. I saw that there's already one question in the Q&A, which I will start with. So an anonymous participant wants to know, how do you think international trials such as the one of Majdi M fits into the broader transitional justice process ongoing in Syria?
Big question. Maybe I can start, and Teresa, if you want to add some ideas. Well, of course, that's, I mean, we all wish that this trial would have influence on Syria, and I myself was not so optimistic at the beginning, fearing that those debates would only happen in Paris and not have any impact on the Syrian soil. However, I could not verify it now, but I heard from several civil parties and witnesses that after the verdict in France, some people intended to file complaints against Jaish al-Islam in Syria. So yeah, I had no means to verify this information, but to me that was, of course, good news, because that's the point, right? And that also showed that justice in France or in Germany is not disconnected from Syria, but there are links.
Thank you, Eva. Yeah. I would just pose the second question because I think that that's one that might be bringing a bit of the difference in Europe to the plate. So one anonymous participant also asked why we refer to those on trial only by their first names and the initial of their surname. We have also changed that in the Majdi N case, but Eva, please.
Yeah, we basically don't use the last name as long as the decision is not final. And since the verdict was appealed, we chose to only mention his first name.
Yeah, so especially in Europe, that is also a big difference to the US or other countries. So long as the trial is not final, the presumption of innocence applies. So that the name of the accused would be still not to be disclosed until it's clear whether he would be convicted or not. And there's another question, which I will pose directly. So regarding the current situation in Syria, we talked a lot about transitional justice, but would you say it would be more appropriate to talk about justice in general? That's also a very big and broad question. Eva, would you like to reply?
Well, when the court debated the its own jurisdiction to try Majdi, I remember one of the Council of the Civil Parties, saying that transitional justice was good, but not enough, basically. We needed criminal justice. And what is the difference? It is that criminal justice focuses on individuals, and transitional justice focuses more on the broader aspect of crimes committed within a broader society. So what he said is that both complemented each other and both were important. And that's also my view. I don't know if that responds to your question, but that's what I can say on transitional justice, that in my opinion is not necessarily enough. Like, some people have to be tried.
Thank you, Eva. You can also pose an additional question or also comment on the reply if you want to. I would also have another question for you. From what you have experienced with this trial, what do you think how accessible this trial was to the public and also to Syrian observers who wanted to follow the proceedings?
Well, I regretted at the beginning that there was less journalists and less researchers, and maybe also less Syrian individuals that attended this trial comparing to the trial last year on against the 3 high-ranking Syrian officials that we also monitored. What I felt is that this trial was really diving into the complexity of the Syrian conflict, and I felt that that's what it was all about. Try to make justice in a very complex situation. In contrast, the accused last year were, they were high-ranking officials, and there was no debate. I mean, they were not present already. The trial was in absentia, and there was no debate on whether they could be. I mean, they were guilty from the beginning. Is that what I want to say? So I regretted that less people attended this important trial. That's what I can say. And maybe on accessibility to the Syrian public, as you said, interpretation was available during the complete trial. However, I cannot say that it was ideal, because sometimes the prosecution, for instance, talked really fast, and some witnesses or civil parties reported that even though they did not understand French very much, they did not listen to the interpretation because it was not always understandable. So it's pretty sure that a Syrian speaker understood less than a French speaker, but still the effort was done, and I mean, we can improve it, but at least everything was translated. About language also, accessibility to the public, but also to the accused. What I need to stress is that he asked at the beginning to talk in English sometimes, and the presiding judge refused it, arguing that, I mean, it did not really say why, but like several times when he started talking, he would talk in English, and maybe 5 or 6 times the president asked him again to switch to Arabic, and he argued that the court would not understand him in Arabic, which is true, or less, that he would be less capable of sharing his feelings and his thoughts and defend himself basically in Arabic. And I think the main reason why the presiding judge refused that he talks in English is that the interpreter were only working in French and Arabic and not in English. So it was basically a logistic issue. And yeah, I think it would have been better if he had been allowed to also speak English at some occasions.
Yeah, thank you. Yeah, we have made very different experiences now in different jurisdictions, but also different courts. So the presiding judges have different understandings of what is the best, and then we'll have to just follow what the presiding judge prefers in that specific case. We have three more questions. We have interpretation. Oh, four more questions for 4 minutes of interpretation. So I'll group them a little bit. I would like to read a question that is specifically for this case, but also for France in particular, and then a couple more broad questions, also again on transitional justice, which seems to be a very relevant and important topic right now, of course. So Eva, for you, is it typical for accused individuals in France to be held in pretrial detention for as long as Majdi N was? Were there concerns voiced over this?
I would say that it's not, from what I heard, not so typical to be held in pretrial detention for that long, but still, that was never unlawful. I mean, it is possible under French law on particular charges to maintain someone in pretrial detention for this period of time.
Thank you. Yeah. And then a quick question. Is the hearing on the 25th for the verdict on the leader immunity in France open to the public? So this Friday, there's a decision by the court.
Yes, I think it is. Yeah, I should check that and maybe verify it. I don't know if someone else in the public had the information. I heard that it is public.
It would be accessible online, correct? So we could, if the person wants to contact us, we can provide a link, but it would probably only be in French, no?
Yes.
Yes. Okay, and then maybe one last question that is a mix of the last ones posed. So how could it be possible that this trial can give hope on the ground, encouraging more national trials in Syria, engaging the new authorities into the national justice? Together maybe with the question of what do you think of the progress in transitional justice in Syria so far? Maybe you can reply within 1 minute, and then unfortunately we'll also have to close the Q&A.
I felt, from what I heard, that it motivated and gave courage maybe to some Syrian victims or witnesses back in Eastern Ghouta to start judicial proceedings there. So that's what I can say on the impact. And then on the broader in development of transitional justice in Syria, well, that's a very broad question, but I think we can refer to our website to see what we are documenting about, and also the crimes that were committed last week and in March against the minorities. So we are still deeply concerned about that and working on investigation about all those massacres. But that's not part. What's also important to stress is that inside SJAC we're splitted. So we have people working on investigation and people doing trial monitoring. And it's important for us to remain separate, with people supporting European courts in particular cases and other people monitoring the trials.
Yes, exactly. To maintain our objectivity and impartiality when we monitor trials. Thank you so much, Eva. We will send the email into the chat. So if you have further questions following this webinar or general questions, you can send any questions and concerns to the email address we'll hopefully be able to provide answers. And please visit our website for information, and especially sign up for our newsletter to see the reports of the Majdi N case coming up in the future. Thank you, everyone. Have a wonderful night or day, everyone, and hope to see you soon.